He should have been restrained in the hospital bed. Instead, he fell out of bed, hit his head, suffered a massive subdural hematoma, died 3 weeks later. Find out what the hospital attorney said to me that basically ridiculed what we were asking for in this case. Come join me as I share with you this remarkable story. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. This gentleman had recently been diagnosed with lung cancer and he was very agitated. He was admitted to the hospital and was being worked up. He was told by the doctors that he was going to be restrained to his bed. The doctors were worried that he would get up, fall, trip, hurt himself, and now the doctors took preventative measures. They specifically ordered him to be restrained to his bed. And if he needed to go to the bathroom or something else, he had a little call button that he could use. So now that's exactly what happened. But now, after 2 days of being restrained, the patient was then sent off for a CAT scan to evaluate what was going on in his lungs. When he returns back from the CAT scan, he's now brought to a different room on a different floor. He's then tucked into his new bed, and now the technician who brought him up, together with the nurse who tucked him in for the night, leaves the room. A few hours later, his adult daughter gets a phone call saying, "We just want to let you know Dad fell out of bed and suffered an injury to his head. We think you should come by." She said, "What do you mean he fell out of bed? The doctor's order said he was supposed to be restrained. How is it possible Dad can get up out of bed and now fall and suffer a head injury?" What was remarkable, and we only learned this after bringing a lawsuit, is that when he was brought to his new room, the nurse and the technician failed to restrain him to the bed. They ignored the doctor's orders, and they were careless. I now presented the defense attorney with the opportunity to try and settle this case early. And you know what he said to me? "We will admit that we might not have restrained him. But," and here's the big but we don't think your client's injuries were as significant as you're claiming them to be." I said, "What do you mean? He died." Yes, that's true, but his life expectancy at that point was severely diminished because he had lung cancer. His life expectancy and the quality of life he could be expected to have, even had he survived, would have diminished his quality of life. Now, I will share with you, those are good, valid defenses that the attorney has raised. But the way that they came across doing it basically ridiculed and mocked our attempt to try and settle this case for a significant amount of compensation. And that was highly offensive. It wasn't until we had finished the entire pretrial litigation phase, and now we're getting close to trial, only then did the defense really come forward and say, "Okay, now we're serious about trying to settle this case." And it was only during the course of mediation, where now we go in front of an impartial mediator who was able to finally help us resolve our differences and come to a mutual agreement about what this case truly was valued at. So why do I share this great information with you? I share it with you because this will happen in virtually every single medical malpractice case that we handle, over and over again. That's what the defense is designed to do. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a great day.